Here I am quoting you as a latest Supreme Court judgment, that is Ghanshyam versus Yogendra Rathi. The facts are this appeal. This is an appeal. This appeal challenges the judgment and decree dated 3/8/2006, which upheld the finding of the trial judge dated 18/8/2005. The trial judge had decreed the suit filed by the plaintiff, Yogendra Reddy, seeking a decree of possession and mezzanine profits in his favor issue. Whether the court below acted in decreeing the suit based on the purported documents of the title set up by the plaintiff. Arguments. The appellant argues that the court below made an error in decreeing the suit based on the plaintiff's alleged documents of title, namely the agreement to sell, registered general power of attorney, and receipt dated 10/4/2002. The appellant contends that these documents cannot establish title in the absence of a registered sale deed, which the plaintiff does not possess. Furthermore, since the ownership of the plaintiff has not been proven in the suit property, the decree should not have been granted. Legal precedent. In the case of Asha M. Jain versus Canara Bank, this court has opportunity to examine the value of similar documents and their ability to transfer title to the claiming party. In that case, the court upheld the reliance on such documents as they were executed for consideration and coupled with the delivery of possession. Therefore, courts below were justified in decreeing the suit in favor of the plaintiff based on the aforementioned documents. Ruling: no substantial question of law has arisen in this appeal, and the pending application is dismissed in limelight. Ghanshyam versus Yogendra Reddy. Intermediate Court JRL. The judgment is made. This appeal has impunged the judgment and decree dated 3/8/2006, which has endorsed the findings of the trial judge dated 18/8/2005, whereby the suit filed by the plaintiff, Yogendra Reddy, seeking a decree of possession and mezzanine profits, had been decreed in his favor. This is a second appeal on behalf of the appellant. It has been argued that the court below had erred in decreeing the aforementioned suit on purported documents of title set up by the plaintiff, that is, agreement to sell, registered general power of attorney, receipt dated 10/4/2002. The said documents could not be relied upon to set up title in absence of a registered sale deed, which the plaintiff did not have. The ownership of the plaintiff not having been proved in the suit property, decree could not have followed. The substantial questions of law have been formulated on page 5 of the appeal. Counsel for the appellant has placed reliance upon AIR 1987, Delhi 36, Imtiaz Ali vs. Nazim Ahmed, AIR 2003, Delhi 120G, Ram vs. Delhi Development Authority 2009, Suraj Lam and Industries Private Limited vs. State of Haryana to support his submission. It is pointed out that the transfer of immobile property valued at more than rupees 100 can be effected only through a registered sale deed. The agreement to sell, GPA, affidavit and receipt could not thus confer or title transfer. It is pointed out that, in judgment of the Apex Court report in Suraj Lam Industries Supra, the court has deprecated this practice of power of attorney sales. None has appeared for the respondent in spite of service. The trial court on the pleadings of the parties have framed 4 issues. This continuation now raised was not raised before the trial judge. Even in the first appellate court, the grievance was that the documents have not been executed by him fraudulently and through misrepresentation. Be that as it may, this court shall deal with his submission made by the learned counsel for the appellant. The plaintiff, in his plaint, has specifically averred that the defendant had executed the aforementioned document, that is, agreement to sell, registered GPA, and receipt dated 10/4/2002 in his favor, and coupled with these documents, the possession of the suit property has been handed over by the defendant to the plaintiff on 10/4/2002 itself. The written statement filed by the defendant has been perused. There is no specific denial on this count. It has not been denied that the suit property has not been handed over to the plaintiff. His continuation was that these documents had been prepared under misrepresentation and in collusion with one Srimati Gaumati were in